Further charges are type 1 count of murder, though.
You don't need a conviction to get discharged from the military. One off-base arrest is enough to trigger separation, kill your clearance, and put your entire career at risk. In this video, I'll walk you through exactly how this happens and the steps you need to take right now to protect your rank, avoid discharge, and stay in uniform. Hi, I'm Nana Knight, and I've spent over 15 years in a courtroom, first as a prosecutor and now as a California State Bar board-certified criminal law specialist and defense attorney. If you need to speak with an attorney for an urgent matter, give me a call at 408-877-6177. Many service members think that if something happens off base and it's being handled by a civilian court, their command won't get involved. But that's not how this works. The military holds you accountable for your actions both on and off duty. Whether you're on active duty or in the reserves, what you do on your own time can still impact your military career. That's just the reality. And if you're arrested for something like a DUI or domestic violence or assault or drug possession, even if you haven't gone to court yet, your command can get the police report about your arrest and start their own internal investigation. And they usually do. That investigation can lead to non-judicial punishment or an Article 15 or other adverse actions against you, or even administrative involuntary discharge from the military with an unfavorable service characterization. And here's the part that surprises most people. They don't need to wait for you to be found guilty. They don't need a conviction. They just need to believe that your behavior does not meet the military standards or violates good order and discipline or is considered a dereliction of duty. This isn't just about what happens in court. It's about whether you keep your job, your clearance, your promotion track, and everything you've worked for. This happened to a client of mine, an Army soldier who got into a fight with his wife. The neighbors called the police. The police came, separated my client from his wife, took their statements individually and separately, and arrested my client. My client spent 2 days in jail and was charged with a felony domestic violence. We were able to get him out of jail pending his criminal case, but the command found out that he was arrested. And within days, his command flagged him, started an investigation, took away his weapons, and reassigned him to another position that he didn't like, and also pulled his clearance. He couldn't go on TDYs or PCS or promote. My client figured that if the civilian case didn't go anywhere, his command would not take any adverse military action against him. My client mistakenly thought that if the civilian case didn't go anywhere, his command would not take any adverse military actions against him. But it doesn't work that way. The military started its own collateral investigation, got his police report, and even tried to interrogate him. We got him pretty fast and began negotiations with his command and the civilian prosecutor who was handling his domestic violence case. We negotiated a huge reduction in the charge with the prosecutor, and we also secured no jail time, no probation, no fines or fees. Because of our background, we were also able to effectively engage with his command and convince his commander not to take any adverse actions against him and to reinstate his security clearance, his promotion, his assignment, and his ability to carry a weapon. And with that outcome, we were able to stop any adverse action against the client and get him back on track. It was a huge win for the client on both the civilian as well as the military front. That's why it's so important to act early, because here is what most people do wrong when they wait. They think that if they don't say anything, things will settle down, or they think they can explain their way out of it later. By the time they realize what's happening, the paperwork is already moving. So what should you actually do? First, get clear on what happened. Write it down. Document everything while it's still fresh in your mind as to who was there, what was said, what happened step by step. That's not just for your attorney, but that's for you, because memory fades and those early notes could end up really helping you down the line. Keep this document and show it only to your lawyer. Second, don't guess your way through this. Get an attorney as soon as possible. And I'm not saying that you should go out and hire the first attorney you find. I'm saying talk to someone who understands both the criminal justice system, the civilian system, and the military regulations. Most lawyers only know one, but you need someone who knows how the civilian case can trigger military consequences and how to guard against those military consequences and build a defense that protects you in both systems. As a former DA, I know how to negotiate with your command and the DA who is prosecuting your case. Third, aim for outcomes that keep your record clean in California. First-time offenders can sometimes qualify for diversion programs or deferred entry of judgment. If you complete them, the charges can be dismissed. That could be the difference between keeping your career and losing everything you have worked for. Fourth, be smart about how your command sees you. That doesn't mean oversharing details or trying to explain your case to your command. It means having your attorney communicate strategically when the timing is right. Letting them know that you're taking this seriously can help prevent knee-jerk reactions or premature separation. And finally, don't make the mistake of thinking that no conviction means no consequences. I've seen service members walk out of court with a clean record only to face an official reprimand, a GOMAR in the Army, or a reduction in rank, or separation by an administrative board hearing weeks later or months later. The military doesn't need a guilty verdict to move forward, and many service members think it's double jeopardy and they can't get in trouble for the same incident in the military and in the civilian system. Well, that's just a false belief and it's wrong. Your plan needs to account for both realities, the courtroom and your command. So bottom line, if you've been arrested, don't ignore it. Don't assume it'll work itself out. It won't. This is when you take control before decisions get made without you. If you're a service member facing civilian criminal charges, don't leave your future to chance. If you want to talk to an attorney who understands both the military system as well as the civilian criminal justice system, and you want somebody you can trust, give me a call at 408-877-6177. The consultation is confidential. And if this video helped you, make sure to check out the next video right over here.